Marshall Chriswell is with us, another installment of Marshall Law. Information on this segment should not be taken as legal advice. Laws can vary by jurisdiction and circumstance, and you should consult with a competent attorney licensed to practice law in your jurisdiction, someone just like Marshall Chriswell. Good morning.
Good morning.
Good to have you with us here today. It's, family situations can be really, really painful, and for one reason or another, wills change and heirs change. And, here's a situation for you this morning. Can a parent disinherit one of their children from a will?
Yeah.
Or from an estate, I guess, huh?
Sure. And it's an all too common situation that I deal with. And the short answer is yes. A parent can disinherit a child. There's no, children don't automatically have an inheritance right under a will. Now, if there's no will, that's a different story, right? Assets pass according to Pennsylvania law, and children are included. But so I guess it's the number one thing is if you have a situation where you feel that you want to disinherit a child, you've got to have a will and you've got to have proper planning. Disinheritance, while, immediately when you think of disinheritance, you think of, maybe a bad family relationship, an estranged relationship between the parent and child, or maybe that the child is a terrible manager of money or has addiction issues or gambling problem or things. And those are all things that definitely come up. There can be other reasons to disinherit a child, though, right? That are not so negative. Maybe you've given one particular child, a parent has given them large gifts during their life, right? And they want to equalize the inheritance, so to speak. And they say, well, I gave my daughter my house, and she has that, and that we're going to consider that her inheritance. So we need to memorialize that in the will. And technically, you're disinheriting your daughter, but you've given her that during her life. Or maybe you have a child that's special needs, and you don't want to go through complex planning to create a trust, and you say, well, we don't want to give them an inheritance because it may throw them off their government benefits or something like that because they'll have too many assets. So there can be good reasons to disinherit a child as well, but absolutely you can disinherit a child.
Mm-hmm. Yeah, but you make the very, very valid point that in order to do that, you have to have an estate plan, and that's where you have to start.
That's right, and the disinheritance, must be clear on the face of the will or the trust. I've seen wills where and you can imagine the conversation between the client and the attorney. The client says, well, I want to disinherit my son, and but I don't want to say anything negative in the will, right? So I don't want to say I'm disinheriting him. I don't want anybody to feel bad, but I don't want to leave him anything. So just leave him out. Just don't put his name there at all. And I've had that conversation with clients. That's not enough. If I have 4 children and I just in the will I just say, well, I'm leaving everything to these 3 children. That opens the door, wide open to a will contest, where the disinherited son comes back and says, "Listen, it doesn't say I'm disinherited. It just doesn't list me, and clearly this was a mistake either by my parents or by their attorney when they drafted the will, and I should have been listed there with my siblings." And so that opens the door wide for a contest. So you've got to have a specific provision in the will that says that I'm disinheriting my child, and that I'm intentionally doing this. But there's a fine line that you walk there as well, because you also don't want to get too specific about the reasons sometimes, right? Because that also can create a situation where if you say, I'm disinherit. I have intentionally made no provision in my will for my son, James, because he's a low-down, dirty liar, and he drinks too much. Well, this gives James the thought or the ability to come back and say, well, no, that's not true. Somebody put that idea in my parents' head, or I've never had a drop to drink in my life, and to factually contest this. And, do they win? Do they not win? Who knows? But, it's you need to be clear, but, often you don't want to go into too many details.
Yeah, well, that's really interesting because it might be that somebody says, I'm just going to not mention them in my will, and therefore they are excluded. But that sort of opens the door at least a crack.
Yeah, no, absolutely. Another situation similar to that is, where children are somebody has children after they create their will, or they adopt a child. Maybe you get remarried and you adopt a child. You adopt your spouse's child. You have a stepchild and you adopt them. So now you've got a new spouse and an adopted child, and you never change your will. And maybe you have a will from several years ago that says, well, I leave everything to my biological children. Imagine somebody that's got a few biological children. They later get married and adopt a stepchild and never change their will. And most people, I think, would surmise that, well, the will that I signed said that my biological children inherit from me, and that's what I want. Mm-hmm. However, your family situation has changed, and Pennsylvania law recognizes an inheritance right for after-born children after you've signed your will, if you have children born or adopted of you, and spouses that you later marry after your will is signed. Pennsylvania law assumes that you would have wanted those folks to inherit from you, and you just didn't change your will. So you've got to go back if you have a change in family situation. I always tell clients this: if you get married, you adopt kids, you have a change in your family situation, you need to be updating your will to reflect what your current wishes are, because you don't want Pennsylvania law to come in and assume what you would want.
In the process of preparing your will, then, your attorney needs to be on the ball and point out to you if that's something that you have expressed to them, that I do not want this child to be a part of this inheritance of this estate distribution, then your attorney should be able to say, well, how many kids do you have? I have 3. All right, I want to leave one of them out. Oh, okay, well, then you had better specifically say that. And that a good, competent attorney is going to guide them through that process, yes?
100%. It's a huge part of our job, and it's having those conversations. I always start with when someone comes and says they want to do a will or an estate plan. There's a questionnaire that everybody fills out and gets back to me that has all that information, but I go through in detail during our consultation, because facts and circumstances that somebody didn't type into a form or write down, things can come up through conversation, and this is Todd, when we talk about AI and online will forms and things like that, mm-hmm. that's often what gets missed, right? Is that conversation where you're asking questions that brings information to the surface that sometimes people leave out when they're just giving you a summary or whatever. So but a good attorney is going to suss out all that information so that we can draft the document correctly.
It really points out to us, as it does every single time, how important it is to actually sit down across the table from your attorney and to figure things out point by point. You have to be very, very specific about your intentions, whether it's preparing a will or some other legal document.
Yeah, absolutely. There's a reason that we go to school for all those years and continue to keep up with continuing legal education credits every year and gain all this experience, to help people through those issues and to make sure that the goals that they have in mind are carried out.
Yeah, absolutely. All right. He's Marshall Chriswell. Marshall, if somebody would like to engage your services in preparing their estate or some other legal matter, what should they do?
You can always give me a call. The number is 724-465-5826. You can stop and see us. We're in the old R&P Cole building behind the post office on Church Street here in Indiana, or go check us out online, www.westernpalawyer.com.
There you go. He is Marshall Chriswell with us this morning. You're actually going to be back with us next Monday, right?
I will, yeah. I'll see you Monday morning, or I'll talk to you Monday morning.
Excellent. Thanks for the time today. We appreciate it.
I appreciate it. Thanks, Todd. Take care.
He's Marshall Chriswell, attorney at law, and you can contact him if you would like to engage his services for whatever your legal matter might be. It's Indiana in the Morning on WCCS 101.1 FM, AM 1160, and WCCSradio.com.